Chairman Darby.
Thank you, Mr. Chairman. First of all, thanks to the members of the committee for being here today, and thanks to the members of the public and other fellow members of the legislature that are sitting in the third row. I want to build on Vice Chair Leach's comments about our role here today. I'm probably the senior member on the dais this morning. I've been here for a few sessions, and I want to focus the committee and the Texas House on our role and responsibility under our Constitution. Our job is to pass laws, and we do so because we listen to the folks who elected us to come down here and make those decisions, to do the hard work, to focus on an issue, come up with the right policy, and then hopefully we'll pass that policy and it'll make a difference in people's lives. Over the years, certainly during my time here in the legislature, there was a flaw in the system. There was a flaw in the habeas corpus process. There was not a mechanism by which people could appeal to the court to grant relief in a situation where science has changed. Now, they refer to it as junk science, but I would say it's just science has changed. The knowledge has changed. And so we saw a problem. So in 2013, and I think Chair Moody and Chair Leach were members of this committee at the time under Senate Bill 344, this legislature took up this issue. We said, let's create some basis of understanding that would allow relief for people who've been charged and are serving time to address the concern about changing knowledge of science. We did that. We set up steps that the Court of Criminal Appeals could look at. Well, we didn't go far enough. And 2 years later, in 2015, we revisited the issue and we changed it again. We changed the steps. And so what I would like this committee to focus in on, I'm not here to determine guilt or innocence. That's not my job. What I am here to do is, has the legislature failed in properly addressing the tenets by which the Court of Appeals can review these cases? Since the implementation of this law in 2013, there have been 74 applications for writ of habeas corpus based upon junk science. Roughly 25 of those cases were people on death row. None of those cases have been affirmatively reviewed and remanded. None of them. The other approximately 50, 2/3 of those, well, about half of those have been sustained. That science has indeed changed, and so we're going to we'll allow new evidence to support a rehearing or a retrial on that case. All of those cases pertain primarily to DNA analysis. We all have gotten caught up with DNA, and we understand that science, and so we recognize that has the ability to determine that the accused didn't do it, but somebody else did. But there's no cases that have been successfully appealed that take a look at the tenets for the shaken baby syndrome that we're dealing with today. Clearly, that body of evidence has changed. And so it's up to this legislative committee to look at the tenets of what's going on here. Has the Court of Appeals taken a position that is inconsistent with the statutory language that we have set out for them to follow? Are they ignoring that and saying, well, yes, it's changed, but it does not determine who the guilt or innocence? That's a level beyond which I originally envisioned in 2013 and 2015. That's a higher level. Is that a level this committee and the legislature wants the Court of Appeals to review these cases? That you actually have to have the scientific facts determine the innocence of the accused? I think not. And in this case, I think so we need to be looking, what I'm looking for with the witnesses is how are we as policymakers to look at the statute that says this is the criteria by which and the lens by which we will review the facts of this case and determine whether or not a new trial should be justified. That's what our business is. That's what our business is, not to determine guilt or innocence. It's not to argue about the death penalty. It's to determine that we as legislators have created hurdles in statute. And is the Court of Appeals following those hurdles in the spirit by which we were intending them to follow? That's what this committee is about. It's not about guilt or innocence. Guilt or innocence will be a byproduct of our hard work. Thank you, Mr. Chairman.
Chairman Darby, thank you very much.